4,152,035 naira 48 kobo. General damages 495,847 847,965 naira 48 kobo. Grand total 500 million naira. The defendant filed a memorandum of appearance on 21st February 2019, a preliminary objection on 28 February 2019, and a statement of defense via a motion on 28 March 2019. The claimant filed a reply to the statement of defense via a motion of 15th May 2019. The defendant amended its statement of defense by a motion of 8 December 2020. The defendant filed a witness statement of Mercy Otefison and Mr. Oluwabode Lawrence Afuye via a motion of 25th February 2021. The claimant filed a counter affidavit to the preliminary objection via a motion on 15th March 2019, and the defendant filed further affidavit on 28th March 2019. Shola, why is our something going off so often like that? The mic.
Maybe we'll change this one. No, this one stays permanently, but this one doesn't. So maybe we'll tell them to change this one and delete this one because of the two projects. This one stays permanent. This one does not. But anyway, this one cannot change.
Why can't this one reach it? This one that is far can reach here. This one that is near cannot reach here. Okay. Facts of the case. The claimant was employed by Starmark in 1995. He worked for the defendant for 20 years from 96 to 2016. On 23rd December 2008, while on afternoon duty, he felt pain in his back, legs, and waist. He went to several hospitals at the expense of the defendant. The defendant paid him full salaries from December 2008 to November 2011, and half salary from December 2011 to July 2016. The defendant terminated the claimant's employment in August 2016 for redundancy and paid him 6,280,663 naira 86 kobo as terminal benefits. It is the claim of the claimant that he also incurred some other expenses in the hospital amounting to 146,400 naira, and that he is entitled to the half salary that was not paid to him from 2011, from December 2011 to July 2016. The case of the defendant. Okay, it's also the case of the claimant that the injury he suffered was as a result of the work assigned to him by the defendant. Under cross-examination, CW1 testified that I was first employed in 1996 by Starmark, a subsidiary of Cadbury Nigeria PLC. My unit was machine operator. I was not the only employer in that unit. We ran 3 shifts in any unit. I ran a shift a day. I only know of my own ailment. I do not know if any other person complained of same ailment. Exhibits TH1, TH2, and TH26 regulated my employment with Starmark up to the time of my termination. The first defendant was responsible for my treatment in all the hospitals I went, and I also paid some of the bills. I have a document to show that I sustained the injury at work. The report I collected from the Catholic Hospital. The paragraph that shows that my injury was incurred during work is paragraph 3 of the second attachment to Exhibit TH17. DW was one Professor Edward O. Komolafe, a doctor with the Obafemi Awolowo University Teaching Hospital. His testimony is that he attended to the claimant He told us the diagnosis and that he gave him a medical report which was signed on his behalf by other medical officers under him. Under cross-examination, DW2 testified that aging and degeneration differs from person to person. It starts earlier in some people. Medically, aging starts at 30 years. Degeneration starts usually at 60 years. Degeneration can start at any age as a result of accident, injury, or trauma. Degeneration can also be hereditary at an early age. Delay or irregular medical attention can aggravate the problem the patient was suffering. The claimant can sit and walk for 6 to 8 hours. The case of the defendant is that the element of the claimant is not as a result of the work assigned to him by the defendant, that there is nothing before the court to show that the ailment was as a result of the work he was doing for the defendant. Also that the claimant abandoned medical treatment for for traditional treatment. He was irregular in the hospital, which also aggravated his situation. And also that by the handbook, the company was only obliged to pay his salary for 2 months sick leave, and then thereafter any payment of salary is at the discretion of the company, and therefore the half salary paid to him was in order. Finally, the defendant contends that it owes the claimant nothing because after all, he was terminated for redundancy and they have paid him. Defendant's final written address, the counsel, you know the submissions you have made. The written address in support of the case of the defendant. I will not take time to read it anymore here, but it is summarized here. The same thing, claimant's written address. Okay, the defendant formulated 4 issues. Claimant also formulated 4 issues. They made submissions in line with it in support of their various cases. Defendant's preliminary objection. The defendant filed a notice of preliminary objection on 28th February 2019, praying that the suit be struck out for want of competence, incompetent reliefs, disclosing no reasonable cause of action, and want of jurisdiction on the part of the court. The grounds of the application are 8 as follows. 1, the claimant respondent did not comply with the condition precedent specified in the Employees Compensation Act before instituting the instant suit. The claimant respondent did not exhaust the available internal remedies specified in the Employees Compensation Act 2010 before instituting this suit. 3, the subject matter of the dispute between the claimant respondent and defendant applicant is one of redundancy for which the claimant respondent has been duly compensated and fully paid. 4, the claimant respondent does not have any reasonable cause of action against the defendant applicant. 5, the suit was not commenced in compliance with the rules of court. 6, the claimant respondent reliefs are not competent to be adjudicated by this honorable court. 7, the claimant's instant suit constitutes a gross abuse of the process of this honorable court. The motion is supported by a 21-paragraph affidavit that brings out the grounds above stated. In his written address in support, learned defendant counsel formulated 4 issues. He made submissions in line with the issues. The main grounds is that going by the case of Maduka versus Art Moving International and another 2013-33, Nigeria Labor Law Report, Part 95, page 297, a decision of this court. This court has only appellate jurisdiction to entertain the case of the claimant because it is workers' compensation that he is claiming. Counsel also submitted that that going by the Workers' Compensation Act, the claimant ought to have first appealed to the board of the NSITF, and then it is when they refuse, then he will also come to this court by way of an appeal. That also it is statute barred because a space of 7 to 10 months have 7 to 10 years have passed before claimant is coming to court. The claimant filed a counter affidavit, formulated 4 issues. All his argument is that the provisions of the Employees Compensation Act does not stop him from coming to this court through any other means, and that the provisions are also contrary to the provision of the Constitution, and so it cannot oust the jurisdiction of this court, that his case discloses reasonable cause of action. We are going to also look at some particular submissions in the course of treating the issues. Court's decision, preliminary objection. Although only 4 issues are formulated for determination in the objection, the arguments of both counsels have raised a number of questions necessitated by the grounds of objection. For purposes of brevity, clarity, and comprehension, the objection will be determined by asking and determining the 8 vital questions raised by both counsels in the course of arguing the 4 issues raised for determination, which are in line with the grounds of the objection. 1. Whether the absence of an affidavit in verification as contained in Form 1 of the Rules of Court renders this complaint incompetent. It is the submission of counsel for the defendant's objector that the absence of an affidavit in verification as contained in Form 1 of the Rules of Court renders this complaint incompetent. Counsel relied on Order 3 of the Rules of Court and Form 1 in the appendix to the rules. He contends that the failure is fundamental and goes to the root of the case. The claimant respondent counsel contended that it is a mere irregularity that does not go to the root of the case and can be condoned. The specific requirements of a complaint are set out in Order 3, Rules 8, 9, and 10, and none of these rules mandate the inclusion of an affidavit in verification, which affidavit only has an administrative relevance and has nothing to do with competence or the justice of the case filed. The sample complaint in Form 1 contains the following: a sufficient affidavit in verification of the endorsement on this complaint to authorize the sealing thereof had been produced to me this dash dash day of dash dash day 20 dash dash. It is the absence of this statement in the complaint that the defendant submits. It is fundamental and goes to the root of the case. How does it affect the root of the case in spite of the fact that the said complaint was filed, paid for, and signed by the registrar has not been pointed out? I agree with the claimant that with the claimant counsel that the omission is a mere irregularity. It is not fundamental and does not go to the root of the case. The insistence of defendant counsel is an undue clinging to technicality, which is said to have been long dead and buried, gone forever. See ANPP versus REC Akwa Ibom State, 2008, National Law Report, Part 1090, 453 at 458 to 45 to at 548 to 549, where the court held as follows: the heydays of technicalities are gone forever. The court is now more interested in doing substantial justice than relying on technicalities, which can only lead to injustice. The verifying affidavit contained in Form 1, and indeed the entire Form 1, is nothing but a guide or sample to be adapted as closely as much as possible by litigants and not a requirement for competence of the process. What is required is substantial compliance and not a strict all or nothing slavish compliance. See Adeyinka Ajayi and Kayode Idowu versus and others versus see Adeyinka Ajayi versus Kayode Idowu and others 2010 LPLR 3673CA where the court held. The court stroke tribunal, whatever the case may be, must avoid undue adherence to legal technicality by strictly applying, as in this case, the rules of procedure. The practice direction was made to guide the proceedings and not to be used to stifle justice. That would be no justice at all. Technicality, having been long dead and buried, must be left in its grave, never again to rise, let alone come near the throne where justice now reigns supreme. This issue is resolved against the defendant objector and in favor of the claimant respondents. 2, whether the claim for special and general damages are lumped together and the reliefs before the court are incompetent or not grantable. It is the submission of counsel for the defendant's objector that the claims for special and general damages are lumped together and the reliefs before the court are incompetent or not grantable, or the 31 Rule 2 of the rules of this court was relied upon. The claimant claims in paragraph 59 of the statement of facts and paragraph 69 of his witness statement as follows, and I read, I quote, whereof the claimant claims against the defendant as follows. 1, the sum of 500 million naira only for compensation and special and general damages for injuries sustained by the claimant in the course of his employment with the defendant, which occurred as a result of the nature of job assigned to the claimant by the defendant, and also for unpaid salary of the claimant's deduction made from claimant's salary. 2, cost of this action. Particulars of special damages. A, salary deductions from November 2011 to July 2016, which is set out therein month by month, but summarized herein year by year as follows. In the claim, he said it out month by month, each month with its own total. But I'm summarizing it here now, each year with its own total. January to December 2011, 50,343 naira 78 kobo. January to December 2012, 918,8636.58. January to December 2013, 709,192 naira 84 kobo. January to December 2014, 775 naira 897 naira 84 kobo. January to December 2015, 910,006 naira, 910,006 naira and 74 kobo. January to July 2016, 670,901 naira 48 kobo. B, I, triometer bicycle 85,000 naira. II, tubic grip 19,200. III, stocky net 19,200. Then IV, 2 pairs of lumbar jacket 24,000. That one, the total is 147,400. So the total so far of special damages is 4,152,035 naira 48 kobo. C, general damages 495,847 naira 548 kobo. Grand total 500 million naira. To cut a long story short, the claim of the claimant are not simply lumped together. so as to make them incomprehensible for the defendant to know what is being claimed against it, or to make it difficult for the defendant to respond to. On the contrary, the claimant simply summarized his claim first and then explicitly set them out distinctly and clearly in a logical and commendable way. The defendant's counsel has shown and demonstrated a clear and precise understanding of the claim and has excellently summarized it in his final written address at pages 21 and 22, paragraphs 512 and 513 as follows. And I quote the defendant counsel, who is the objector, on this claim, how the claim is made. I'm quoting him now. The claimant has only stated in his statement of claim what he claims as special damages and general damages. He specifically pleaded the sum of 4,152,035 naira 48 kobo as special damages and 495,847 I think there is a problem with these figures, or I don't know how to read the figures anymore. Let me go back to. Okay, sorry. No, I'm not used to these figures, this kind of figures. 495 million 846,965 naira 48 kobo as general damages. Then he continues, with respect to the alleged deductions, the claimant claimed to have been made from his salary from December 2011 to July 2016. He is thus claiming the remaining part of the said salary. The other part of the special damages is the alleged personal expenses incurred in the treatment of his condition. This is why I said the defendant counsel clearly understood and excellently summarized it. He cannot at the same time say the thing is so lumped up that it is not grantable, when he can understand it and summarize it this excellently. The reliefs before the court are therefore not incompetent, and they are grantable if proven. This issue is resolved against the defendant, objector, and in favor of the claimant respondent. 3, whether the claimant is the proper party to sue in this suit. The learned defendant objector's counsel has submitted that the claimant is not the proper party to institute the instance suit, but either the National Social Insurance Trust Fund Management Board in respect of the compensation for injuries, or the National Union of Food, Beverages, and Tobacco Employees in respect for any compensation for redundancy. The learned claimant's counsel contended that the claimant respondent is the proper party to sue in this case, as the contract of employment is stricto sensu between the claimant respondent and the defendant applicant. The court is unable to comprehend why an aggrieved employee who said he suffered injury or illness in the course of employment and is entitled to compensation, that half of his salary was withheld for a period of time without justification, is not the right person to sue. Similarly, the court is unable to comprehend how and why the National Social Insurance Trust Fund Management Board, saddled with the statutory duty of paying compensation to employees in respect of injuries incurred in the course of employment, should be the one to sue in respect of such compensation and not the employee who suffered the injury. The claimant is not making a claim for payment of redundancy benefits or any terminal benefits. Even if he is, how is it that it is the National Union of Food, Beverages, and Tobacco Employees that should sue in respect of any compensation for redundancy, and not the employee who alleges such entitlement, is left to imagination. The submission of the objector's counsel on this issue is offline, and this issue is resolved against the defendant objector and in favor of the claimant respondent. 4, whether the counter affidavit cannot be acted upon because of contradictions in some paragraphs. Learned Defendant Objectors Counsel contended. Okay, Learned Counsel for the defendant objectors contended in his reply on points of law that paragraph 5, 7, 16, 20, 21, and 35 of the claimant's counter affidavit, 6 paragraphs out of 58 paragraphs, contain lots of inconsistencies and contradictions, so the court should exercise great caution not to pick and choose from the evidence before it, that the contradictory evidence of the claimant respondent cannot be acted upon by this court. I have read the said paragraphs 5, 7, 16, 20, 21, and 35 of the claimant's counter affidavit. The alleged inconsistencies and contradictions are inconsequential to the issue raised in this objection and cannot vitiate the whole 58 paragraph counter affidavit. This issue also was not raised in the objection, but in the sorry, gentlemen, there is an error. This question is resolved against the defendant objector and in favor of the claimant respondent. 5, whether statute of limitation is applicable in this suit. All these are the arguments of counsel submitted. So you can see that it cannot just be 4 issues. So whether statute of limitation is applicable in this suit. The defendant objector's contention that this suit is statute barred is based on the contention that if the cause of action arose in 2008 per paragraph 12 of the statement of facts or in 2011, the claimant had 1 year to apply to the NSITF or 3 years in exceptional cases by Section 6 of the Employees Compensation Act. This case, having been filed in 2018, was either 10 years or 7 years out of time. Without much ado, this contention raises the question whether the claimant is not out of time to make a claim against the National Insurance Trust Fund Management Board in view of Section 6 of the Employees Compensation Act. The NSITF who alone is entitled to raise such objection, is not a party to this suit, and the defendant cannot hold brief for a non-party. This issue is resolved against the defendant objector and in favor of the claimant respondent. 6, whether the case of the claimant does not disclose reasonable cause of action. The learned defendant objectors counsel submitted that where, as in this case, there is no fact or combination of facts giving a right in the respondent herein as claimant to sue the applicant, or where respondent's case does not disclose a prima facie case against the applicant as comprised in this suit, this action can be said to have been instituted without a reasonable cause. That even if the allegation contained in the statement of facts of the respondent are established, the respondent is not entitled to any remedy whatsoever against the applicant, but against the Nigerian Social Insurance Trust Fund Management Board, Section 56(1) and 58 of the Employees Compensation Act 2010, Maduka versus Art Moving International and another. 2013-33 Nigerian Labor Law Report, Part 95, page 297. The claimant is an aggrieved employee who said he suffered injury or illness in the course of employment and is entitled to compensation. That half of his salary was withheld by the defendant, his employer, for a period of time without justification, and is entitled to pay the said withheld salaries. These allegations constitute a good example of reasonable cause of action to be litigated upon and be determined on the merit. Whether or not the defendant is the one liable for any of the claims is not a question of no cause of action, but a question to be determined after taking evidence. This issue is resolved against the defendant, objector, and in favor of the claimant respondent. 7. Whether claimant must comply with Section 6 and 55(4) of the Employees Compensation Act or can elect to take his case straight to the court. Put another way, whether this court only has appellate jurisdiction in claims for injuries suffered in the course of employment. Learned Defendant Counsel argued that the crux of the complaint of the respondents is workmen employee compensation for injury resulting from employment to the claimant the claimant has no freedom to elect to act against the express provisions of a statute that in claim for compensation for injuries suffered in the course of employment, claimant must comply with Section 6 and 55 of the Employees Compensation Act by making a claim from the Nigerian Social Insurance Trust Fund Management Board under the Employees Compensation Act before coming to this court in its appellate jurisdiction, relying on the decision of this court in Maduka versus Earth Moving International and another 2013-33 Nigerian Law Report, Part 95, page 297. Learned Claimant Counsel argued that going by the combined effect of the provisions of Order 3, Rule 5.1 and 2, and Order 3, Rule 12.2 and 3 of the rules of this court, it is discretionary for the claimant respondent to elect to take his case to this honorable court or to the board under the Employees Compensation Act, that Section 6 and 55(4) of the Employees Compensation Act are inconsistent with the provisions of the 1999 Constitution. Now, Section 6 and 55(1)(4) of the Employees Compensation Act 2010 provide as follows. I will quote them. 6.1. An application for compensation shall be made on the form prescribed by the board and shall be signed by the employee or the deceased employee's dependent. Sub 2. Unless an application is filed or a determination is made within 1 year after the date of death, you understand? After the date of death, injury or disability arising from the occupational accident or disease, no compensation shall be payable except as otherwise provided in subsection 3 of this section. Sub 3. If the board is satisfied that there existed special circumstances which precluded the filing of an application within 1 year after the date of the occurrence, the board may pay the compensation provided by this act if the application is filed within 3 years after that date. Sub 4, the board may pay the compensation provided under this act for the period commencing on the date the board received the application for compensation if A, the board is satisfied that special circumstances existed which precluded the filing of an application within 1 year after the date referred to in subsection 2 of this act section, and B, the application is filed not more than 3 years after the date referred to in subsection 2 of this section. Sub 5, notwithstanding the time limit set in subsection 2 and 3, the board may pay the compensation for an occupational disease provided under this act if A, sufficient medical or scientific evidence was not available on those dates for the board to recognize the disease as an occupational disease, and this evidence became available on a later date, and B, the application is refiled. Section 55(1) and 4. 55(1), a person aggrieved by any decision of the board may appeal to the board for a review of such decision. 4. Sub 4, an appeal shall lie from any decision of the board under subsection 1 of this section to the National Industrial Court. The contention that the crux of the claim of the complaint of the respondent is workmen or employee compensation for injury resulting from employment is not borne out from the pleading, but the defendant's surmising. There is nowhere in the statement of facts or reliefs that the claimant even made any reference to workmen or employees' compensation. The defendant cannot create a different case for the claimant just for the purpose of defeating same. I have read the decision of my Lord Honorable Justice Ibrahim A. of blessed memory in the case of Maduka vs. Art Moving International and another relied upon by defendant's counsel. The decision of my Lord therein was based on the fact that the claimant was expressly asking for workman's compensation, not simply asking for general damages for injuries incurred in the course of employment, as in this case. This is what my Lord said at page 331 of the report, and I quote my Lord Howard. The Employees Compensation Act provides in section 55 that a party seeking for compensation must first exhaust the procedure before the board, and thereafter he has a right of appeal to the National Industrial Court. With this provision, it is quite clear that the claimant who is asking for compensation, and I underline this next one, and in fact, whose complaint expressly states that he is asking for workman's compensation, cannot approach the court without first going through the process enshrined in the said Employees or Workmen's Compensation Act. In this case, the claimant has not in any way whatsoever tied his claim to the Employees Compensation Act. The facts of the case of Maduka Supra and the present case are not on all fours, and each case is determined based on the facts of that case. Accordingly, the case of Maduka is not applicable to the instant case. See Prince Abiodun Adesina vs. Honorable Ifedayo Sunday, Abegunde and others, 2009 LPLR 3613 CA, where the court held. What is more, it is a settled principle of law that each case is determined by the court based on the peculiar facts and circumstances of the case, as no two cases are ever really completely the same. By section 12(1) of the Employees Compensation Act, it provides as follows, and I quote, the provisions of this act are in lieu of any right of action. I underline that, in lieu of any right of action, statutory or otherwise, founded on a breach of duty of care or any other cause of action, whether that duty or cause of action is imposed by or arises by reason of law or contract, express or implied, to which an employee, dependent, or member of the family of the employee is or may be entitled against the employer of the employee or against any employer within the scope of this act or against any employee in respect of any death, injury, or disability arising out of and in the course of employment and where no action in respect of it lies. In Luke Udemba versus Charles Nwabweze, 2016 LPLR, the Court of Appeal per Agube JCA defines the phrase in lieu of as follows. Accordingly, the learned counsel for the appellant, and in line with the definition of the term in lieu by Black's Law Dictionary, 9th edition at page 558, see also page 791 of the 7th edition, has rightly submitted that it means instead of or in place of, in exchange or return for. So that means if you take action B in lieu of action A, you can no longer take action A. But it does not mean that you could not have chosen to take action A in the first place. This is exactly the sense or interpretation conveyed in Order 3, Rule 12.2 and 3 of the 2017 rules of this court, which provides as follows. An employee...
I'm sorry, my lord.
Sorry, let me continue. An employee or an employee's dependent may file an originating process for compensation on any matter relating to or connected with death, injury, illness, or disease at the workplace or in the course of the employee's employment or engagement, provided that the employee or the employee's dependent has not filed an appeal to the board implementing the Employees Compensation Act 2010 in accordance with the provisions of Section 55(1) of the Employees Compensation Act 2010. Sub 3, where an employee or an employee's dependent has elected to take the employee's request for compensation to the board implementing the provisions of the Employees Compensation Act, such employee or employee's dependent shall not file an originating process with the National Industrial Court. A combined reading of Section 12(1) of the Employees Compensation Act and Order 3, Rule 12.2 and 3 of the rules of this court reveals that an employee can sue for a claim for compensation for injury arising in the course of employment by any other action, or claim through the Employees Compensation Act in lieu of any such other right of action, but not the two at the same time, and the fact that an employee chooses to sue under the Act does not mean that he could not have sued under any other law or contract, and vice versa. This also leaves no room for the argument that Section 6 and 55(4) of the Employees Compensation Act are inconsistent with the provisions of the Constitution. Accordingly, an employee has a choice to claim for compensation under the Employees Compensation Act or to sue directly in the National Industrial Court for compensation or damages under any other right of action. This question is resolved against the defendant, objector, and in favor of the claimant, respondent. Counsel, are you observing any error of facts in the course of reading the judgment?
As the court pleases, my lord, it would appear that your learned brother, Justice Keomi, had already ruled on this preliminary objection as far back as 2019, my lord.
Well, you have raised it and have already this thing. Keep that aside. You can settle it after.
As the court pleases.
If you had raised it and it was ruled upon, and your colleague did not even bring it to my notice, that error is caused by both of you, and is also caused by you insisting on moving the said PO.
No, we didn't move it again, my lord.
You say?
We didn't move it before my lord, my lord. It was before your learned brother.
Okay. Well, the records will show for themselves.
As the court pleases.
Thank you.
And it was dismissed.
Okay. Then 8, whether the claimant is not entitled to any remedy whatsoever against the applicant, but against the Nigeria Social Insurance Trust Fund Management Board, pursuant to Section 56(1) and 58 of the Employees Compensation Act 2010. Since the claimant did not bring his claim under the Employees Compensation Act, but elect to bring his claim under other rights of action, his case will be determined on the merit of that right of action, and the Act will not be used to determine his claim. The claimant can prove his case under whatever right of action before this court. This question is also resolved against the defendant, objector, in favor of the claimant, respondent. On the whole, having resolved all the issues or questions against the defendant applicant in favor of the claimant, respondent, the objection first in its entirety as wanting in merit and same is hereby dismissed. So at least
As the court pleases.
We have not done anything contrary to the earlier ruling, if there was.
As the court pleases.
Yes. Merit of the case. Having considered the pleadings, evidence, and exhibit standards, and the final written addresses of both counsel, the court is of the opinion that a loan issue arises for determination, which is whether the claimant has proven his entitlement to any of the reliefs claimed. We shall begin with the preliminary issues of admissibility of documents. Admissibility of documents standards. A. Exhibit TH14. Learned counsel submitted that Exhibit TH14 claimant's alleged picture paragraph, photograph is computer-generated evidence. However, the claimant failed to comply to accompany this document with the requisite certificate or certification in the manner required by law, and thus it's inadmissible. The claimant made no attempt to comply with the provision of the Evidence Act in respect of Exhibit TH14. The provision of Section 12 of the NICN Act 2006 cannot be invoked herein, as there is no any reason whatsoever for any departure from the provisions of the Evidence Act in respect of the said picture. Exhibit TH14 is therefore expunged and marked as rejected. Exhibit TH17. With respect to Exhibit TH17, defendants' counsel submitted that the purported receipts are unreliable documents, as some of the documents are not in the name of the claimant. The claimant is neither the maker of the exhibits nor the recipient. Assuming without conceding that the exhibits were relevant and admissible, we contend that the said exhibits were made in 2009, and same did not prove that the claimant personally incurred the cost or paid the monies contained in the receipts for his treatment. First, the claimant did not show any evidence that he actually paid the said sums. We observed that some of the receipts were issued in the name of Taye and Azan. The court talks now. I have looked at Exhibit TH17, 3 cash invoices. One is not issued to any named person. The other 2 invoices for 2012, 85,000, and 2013, 62,000 are issued to Hassan Taiwo, the claimant herein. None of the invoices is issued to any Taye or Azan. The 2 invoices issued to the claimant have written on them, paid, and that transforms the invoices into receipts. The second and third invoices, as indicated above, remain admitted as already marked. Exhibit TH13. Learned Defendants Counsel argued that Exhibit TH13 was procured by the claimant in contemplation of the instant suit. All the documents submitted by the claimant showed that he visited the hospital between 2009 and 2011. However, only Exhibit TH13 suddenly stated that the claimant visited the hospital on 25 June 2018, while this suit was instituted in December 2018. Claimant did not show any records of his attendance at the hospital between 2011 and 2017. He urged the court to discountenance and expunge Exhibit TH13. The claimant was, now the court is talking. The claimant was disengaged in August 2016. Exhibit TH13 was obtained on 23rd July 2018, and this suit was filed on 20th December 2018. It stands to reason that at the time of obtaining Exhibit TH13, this suit was being contemplated. Exhibit TH13 qualifies as document obtained in contemplation of litigation. Exhibit TH13 is accordingly expunged and is to be marked as rejected. Exhibit TH21. With respect to TH21, Cadbury's Handbook, counsel argued that the claimant had, during cross-examination, admitted that his contract of employment was governed by Exhibit TH1, TH2, and TH26, his letter of employment, confirmation, and star mark handbook. That facts admitted needs no further proof. Having admitted the above, Exhibit TH21 is not relevant to the claimant's case. It must be noted that parties are agreed, as stated by DW1 under cross-examination, that star mark was duly acquired by the defendant in 2013 From 1995, when the claimant was employed until the acquisition in 2013, the Handbook of Starmark TH26 governed the claimant's employment with Starmark. And from the time of the acquisition in 2013, the Handbook of the Defendant, Exhibit TH21, governed the employment of the claimant with the defendant. This position was correctly stated by DW1 under cross-examination when he said, at the time of termination, it was the defendant's rule of service that governs the claimant appointment. Since the ailment of the claimant started in 2008 before Starmark was acquired by the defendant in 2013, both Exhibits TH21 and TH26 are relevant in this case. Exhibit TH21 therefore remains admitted as marked. Exhibit OLA1 to OLA16. The claimant counsel contends that DW1 tendered Exhibit OLA1 to OLA16 in which he is not the maker, that documents produced by parties in evidence in course of hearing are to be tested in open court before the court can evaluate them to determine their relevance in the determination of the case upon which the documents are relied upon. For this reason, any document tendered by parties without calling the maker attracts no probative value. The court now talks. These documents comprise of referrals in favor of the claimant, reports or updates addressed to Starmark, the claimant's former employer, or the present defendant. Some are letters from Starmark or the present defendant to the claimant, correspondences with counsel in respect of the claimant, promotion letters of other employees in proof of the allegation that the promotion exercise were general. These are documents that are generally expected to be in the defendant's file, and a staff of the defendant, such as DW1, is entitled to tender them without being the maker of those documents. However, Exhibit OLA9 is a mere worthless piece of paper titled List of Staff Affected in 2016 Reorganization Exercise. This document is not on the company letterhead. It is not an internal memo. It is not dated, and it is not authored. The position of the law is that such a document is worthless, and I so pronounce it. Exhibit OLA9 is accordingly expunged and marked rejected. Similarly, Exhibit OLA10 is comprised of emails. An email printout is a computer-generated document that requires certification, but the defendant simply tendered these emails as of right. They have not passed the test of admissibility. Exhibit OLA10 is accordingly expunged and marked as rejected. Whether the claimant has proven his entitlement to any of the reliefs claimed. This is the main merit. In determining this issue, the court shall answer the question in relation to each head of claim. It is pertinent to note that the defender made an issue out of the fact that the claimant's appointment was determined based on redundancy, and he has been paid redundancy benefits and other terminal benefits. This is an unnecessary academic exercise for the court, as the claimant is not challenging his termination, nor is he asking for redundancy benefits or any terminal benefits in this suit. He is not. So the court will not waste its time determining such issues. So we go to A, special damages, 4,154,035 naira 48 kobo. 1. Outstanding salaries from December 2011 to July 2016, which is 4 million and 4,635 naira 48 kobo. It is the case of the claimant that he was paid half salaries from December 2011 to July 2016. The defendant did not deny, but admits this. The justification according to the defendant is that Clause C9F of Exhibit TH26 as well as Clause D7C of Exhibit TH21 provides as follows. Permanent non-management employees will be allowed up to 2 months on full pay and another 2 months on half pay as sick leave within 1 calendar year. Payment of wages for any further sick leave will be at the discretion of the management. Thus, the claimant cannot be entitled to any payment for compensation or damages for alleged deductions for the period of December 2011 to July 2016 as the payments that were made to the claimant during the said period were discretionary to the defendant. All these are the submission of defendant's counsel. This court has earlier held in the ruling on the objection that SBTH 26 governed the claimant's employment with Starmark until 2013 when Exhibit TH21 began to govern his employment with the present defendant. The claimant's illness started in December 2008 and the half payment started in December 2011, all under Starmark and Exhibit TH26. Claimant never returned to work since May 2009 until he was disengaged in 2016. Yet he was on half salary from December 2011 till July 2016, while the defendant footed his hospital bills. How does the defendant or the claimant the half salaries claimed in spite of the above provision of the rules and the fact that he was ill throughout and did not work is what the claimant has not explained. The claimant does not claim that he suffered the injury due to negligence of the employer by failing to provide what it ought to provide for his protection against such injury. It is in view of this Okay, it is the view of this court that given the facts of this case, Clause C9F of Exhibit TH26 as well as Clause D7C of Exhibit TH21 constitute a valid defense to this head of claim. This head of claim fails and is dismissed. Hospital expenditure 147,400. It is the evidence of the claimant that he spent 147,400 while in hospital to buy for himself 1 tri-meter bicycle, 85,000, tubic grip, 19,200, stocking net, 19,200, 2 pairs of lumbar jacket, 24,000 naira, total 147,400. Claimant's counsel submitted that Section L2A and B of Exhibit TH21 provides, and I quote, accidents and injuries, whether minor or serious, must be reported without delay to the clinic and or the safety unit. Any compensation will at a minimum be in accordance with the Workmen Compensation Act 1985 or any other act or regulation relevant at the time of the accident. B, the company will cover the cost of medical treatment arising from accidents occurring while the employee is at work. However, the company shall in no way be liable to or responsible for medical expenses arising from any accident outside the course of legitimate employment. The 2 receipts constituting Exhibit TH17 actually amounted to 147,400. One of the receipts is dated 14th March 2013, so it comes under Exhibit TH21, Cadbury, that's defendant. Section L2A and B of Exhibit TH21 is headed accident, and the word injury therein must be understood as injury arising out of accident. This is necessarily so because there is also L1, which is headed medical treatment, and it provides On the recommendation of the company medical director, the company shall pay cost of medical treatment except in the following cases: dental, maternity treatment, eyeglasses, artificial limbs, or other surgical appliances. Since the case of the claimant is not that he suffered injury as a result of accident at work, but that he took ill while at work, the applicable provision is L1, and the items, 2 big grips, stocky net, and 2 pairs of lumbar jacket in the receipt dated 14th March 2013 come under the above exceptions. The other receipt is for the sum of 85,000. It's dated 2nd April 2012, so it comes under Exhibit TH2, star mark. Paragraph E3 of TH26, not EH2. EH26 contains similar provisions as L1 of TH21. It is also the finding of the court that the item on the receipt dated 2nd April 22, that's tri-meter bicycle, also comes under the exceptions in E3 of TH26. The implication of the above findings is that the claimant is not entitled to the sum of 147,400 spent on tri-meter bicycle, 2 big grips, stocking net, and 2 pairs of lumbar jacket. This head of claim fails and is dismissed. General damages, 495,847, 495,847,965 naira 48 kobo. Parties have joined issues on whether or not the claimant's injury was suffered as a result of the nature of work assigned to him by the defendant. The claimant is claiming for general damages for injuries sustained by the claimant in the course of his employment with the defendant, which occurred as a result of the nature of job assigned to the claimant by the defendant. In the body of the statement of facts and the evidence, there is no more allegation against the defendant than this. Damages of whatever nature, special or general, is a function of liability. To succeed in a claim for general damages, there must be a wrong act of the defendant complained of, a default on the part of the defendant, a breach of contract by the defendant, or a harm resulting from a tort by the defendant. See FBN PLC and others versus AGF and other citations they are fully supplied, where the court held damages have been defined as the pecuniary compensation which the law awards to a person for the injury he has sustained by reason of the act or default of another. Whether that act or default is a breach of contract or a tort, it could also be expressed as the recompense given by process of law to a party for the wrong that another has done him. Also in Afolabi and Ola citations supplied, the court held the law regarding to general damages presumes damages as flowing from the wrong complained of by the victim. Such damages in law need not be specifically pleaded and strictly proven. In other words, general damages are compensatory damages for harm resulting from the tort for which the party has sued. They made reference to other cases there. I also cited the case of Sabon Gida and another versus Dan Namashi, citation fully supplied, where the court held. What then is general damages? In UBA, PLC, and Ogun Dokun, general damages has been defined to be general damages are damages which the law implies or presumes to have accrued from the wrong complaint of, or as the immediate, direct, and proximate result of, or the necessary result of the wrong complaint of. It is awarded by the court where it cannot point at any measure in to access the loss caused by the wrong complaint of, except the opinion and judgment of a reasonable man. Other matters are referred to there. It is not the allegation of the claimant that the illness was as a result of accident at work. No allegation that he was forced to do the work assigned to him. No allegation of forced labor. There is no allegation of any default on the part of the defendant that resulted in the injury or any wrongdoing on the part of the defendant resulting in the injury. The claim is simply on the basis that the illness occurred while at work. Such claim can only succeed under the Employee Compensation Act, where there is no requirement on the claimant to prove any fault of the employer or to prove that the injury was as a result of the nature of work assigned to him by the defendant. But the mere fact that the illness occurred during employment is enough to make the claim through the NSITF Management Board, to which his employer by law pays into the fund created by the Act for compensation of employees. Any other claim for compensation or damages for workplace injury outside the Act must be based on contract or tort of negligence. The claimant must prove the duty owed and the failure to carry out such duty. He must prove the wrong done by the defendant, and the wrong is not proven by merely establishing that the injury was suffered as a result of the work assigned to the claimant by the defendant. Outside the Employees Compensation Act, there is no damages without a wrong or violation of a legal right. A determination of whether or not the injury of the claimant was as a result of the nature of work assigned to him by the defendant is therefore irrelevant, as the question of what wrong has the defendant done by assigning such duty to the claimant to perform will remain unanswered, since the claimant did not base his claim upon any alleged wrong done by the defendant. The claim of the claimant is not based on any law, contract, negligence, or any violation of a legal right. It is neither contained in the claim nor the final written address of claimant counsel. Where there is no wrong established against the defendant, there can be no damages awarded against the defendant. This head of claim also fails and is dismissed. For all the reasons above, the claim of the claimant fails in its entirety for lacking merit, each party to bear its cost. This is the judgment of the court.
As the court places.
You are welcome.
We want to say thank you.
Let me record Iluyemi first.
As the court places.
Yes, Iluyemi said we are grateful. Yes, Ogaba.
My Lord, we are very grateful for the very erudite judgment of the court, which meets the justice of the case. We remain very grateful, my Lord. Thank you, sir.
You are welcome. Today is 18th. A copy of the judgment will be ready for collection on Monday.
As the court places.
Okay. Thank you. We will leave the Zoom now.
Thank you, my Lord.
You're welcome.
Congrats.
Thank you, sir.